simply saying, I thought we went over that comprehensively yesterday. If you have anything else to add, go ahead, but let's move on to the next point today. These do not come anywhere near showing any bias, manifest lack of independence or impartiality. And so finally, with that, I'll turn the floor over to my colleague, Mr. Polachek, who will discuss.
Yes, we're good. Now, can we just have a check on the time used?
We have half an hour.
It's 30 minutes. Yeah, we started late and we've had many questions from the tribunal. So 30 minutes. So we
Okay,
finished.
and that takes out the question, the longer time. Okay.
So the additional cost.
Well, I hope that the first 30 minutes that we lost because of technical problems, they don't charge us for that. But they add the 15 minutes because that's attributable to the division. Go ahead. If you could skip some slides, it'd be appreciated.
Thank you. I will certainly skip some slides in the interest of time. Good evening. I am Petr Polachek, counsel for TECO, and I will present TECO's argument concerning Guatemala's application for annulment of the resubmission award on account of its reasoning concerning damages. And we will skip to page to slide 80. So this one. So by way of background, in the original arbitration and in the resubmission arbitration, both parties relied on and adopted the damages calculations by their experts. For TECO, the expert was Mr. Kaczmarek. For Guatemala, the expert was Dr. Abdallah. And in the original arbitration, as well as in the resubmission arbitration, both parties calculated the loss of value damages as the difference in the value of EXA on the day of its sale in October 2010, in the actual scenario and in the but-for scenario. And this basic damages framework was adopted also by the original tribunal and by the resubmission tribunal. And Guatemala argues that the resubmission award failed to state the reasons on which it is based with respect to the actual value and also with respect to the but-for value. So I will address each in turn. Slide 81. So as regards the actual value of EXA in the original arbitration, there were no significant differences between the parties, and you can see here on the slide what Guatemala said about it in its post-hearing reply. It said that there are no significant differences between the parties. Slide 82. So in the resubmission arbitration, there also were no significant differences between the parties with respect to the actual value. And that is because Guatemala's expert, Dr. Abdallah, calculated the actual value as a range from $518 million to $582 million. And he did that, he derived that from the sale price of EXA. And Mr. Kaczmarek's value, actual value of EXA was within Dr. Abdallah's range. And so, as you can see on cross-examination at the resubmission hearing, Dr. Abdallah testified that any figure within his range of actual values of EXA was reasonable to use in the actual scenario as EXA's value. This is the testimony of Guatemala's expert. This is what was before the tribunal when it made its award. Guatemala, let's stay on this slide. So Guatemala never sought to correct that testimony. It had an opportunity to redirect Dr. Abdallah at the hearing. When the resubmission tribunal asked whether Guatemala had any redirect examination, Guatemala said no. Slide 83. So this slide reproduces the beginning of the tribunal's reasoning on actual value. In the interest of time, we can move on. The committee can read this. So here, the resubmission tribunal notes the range of methodologies employed by the parties, by the experts, and the explanations in the Navigant report, and it decided to accept Mr. Kaczmarek's actual value of EXA, which again was within the range of the values presented by Guatemala's own expert. And so, in short, the resubmission tribunal adopted an actual value of EXA that was within Guatemala's own range of actual values. The tribunal's reasoning regarding EXA's actual value, as stated in the resubmission award, is coherent. It is easily understood, and that is the end of the inquiry under the jurisprudence. In any event, Guatemala's complaint does not go to the existence of reasons, but it goes to the adequacy of the reasons. This is slide 86, and as the jurisprudence demonstrates, that's not a basis for annulment. Slide 87. And given that the actual value of EXA that was adopted by the tribunal was within Guatemala's own range of actual values, the tribunal's decision on actual value could not have had and did not have any serious adverse impact on Guatemala. And this is yet another reason for dismissing Guatemala's application as it relates to actual value. This is supported by the committee decisions in Tulip v. Turkey and Orascom v. Algeria, among others. Slide 88. So in the reply, Guatemala for the first time argued that there is a decisive question that the resubmission tribunal failed to address. And according to Guatemala, that question is whether the sale price of DECA2, that's the company that owned EXA among other assets, so whether that sale price should be used as the basis for calculating EXA's actual value. According to Guatemala, this was a decisive question that the resubmission tribunal failed to address. This was raised for the first time in Guatemala's reply in this annulment proceeding. But again, because the actual value of EXA adopted by the tribunal was within the range of Guatemala's own range of actual values, this was not and could not be a decisive question. Guatemala, slide 88, Guatemala is attempting to suggest that it was a decisive question because depending on which end of Dr. Abdallah's range of actual values we use, we might end up with zero damages. I think we heard that also earlier today in Guatemala's opening. That is false. Guatemala cites Dr. Abdallah's third report as support for that proposition. But if we read the relevant parts of the Abdallah report, we see that he speaks about the tariff period after 2013, and it has nothing to do with the damages for the remainder of the 2008 to 2013 tariff period. Slide 89. And Guatemala commits the same misrepresentation with respect to Dr. Alexandrov's question. At the hearing, again, these questions related to the time period after 2013 and had nothing to do with the remainder of the 2008 to 2013 tariff period. So there's no basis for this assertion that this is somehow a decisive question. Slide 90, we can skip that. We will go to slide 91. And this is just to make the point that this belatedly submitted new ground for annulment is inadmissible because it was presented a year and a half after the resubmission tribunal's decision on supplementation, and that means that it is way beyond the 120-day deadline under the ICSID convention. It is also contrary to this committee's procedural order number 1, paragraph 15.3. Slide 92. So to the extent that the resubmission tribunal omitted to decide a question, which it did not, but even if it did, the remedy would not be annulment. The remedy would be a request for supplementation, and that this is so is supported by Cube v. Spain, Enron v. Argentina, and the history of the ICSID Convention. Another independent reason for dismissing Guatemala's application as it relates to the actual value of EXA. Turning to the but-for value of EXA, so slide 93 reproduces the initial part of the reasoning of the trial of the resubmission tribunal. We can move on. So here, this is paragraph 138 that was discussed a lot today. And as you can see, the tribunal stated that claimant is entitled to its share of the portion of the cash flow shortfall that related to the period from 2010 to 2013, and that the amount of damages is $26,793,001. That is the amount that was calculated by Mr. Kaczmarek. And if we would go just back up to slide 95. Okay, so the tribunal also made its own determination that the same data and methodology presented by Mr. Kaczmarek that had been accepted by the original tribunal is to be employed to calculate the amount of the loss of value damages in the resubmission case. And there was a discussion today about that. So I want to focus on that a little a little more. So let's go to the next slide. And here, this is the statement by the tribunal about the same data and methodology. And you can see again, there is a footnote there, footnote 122. That's where the resubmission tribunal provides its support for why it is making that statement. And you can see that in footnote 122, there is a reference to the Navigant report, other portions of the transcript, and then at the end, there is a reference to day 4, page 996, lines 11 to 21 of the transcript. And if you look up above, in that portion of the transcript, the president of the tribunal, Professor Lowe, asked claimants point blank, claimants taken the point of view that the historical damages claim logically could go forward to 2013. What's your position on that? And Mr. Blackaby, Guatemala's counsel, said, I think in terms of going to 2013, in terms of that question, that must be right. And he did not stop there. He continued. He said, those figures are obviously linked to the whole tariff review and the whole tariff period. And again, he's talking about the entire 2008 to 2013 tariff period. So again,
that was a question to Guatemala because he said to claimant. So I think the record shows claimants, but it was to Guatemala.
Yes.
Because it was answered.
Thank you for the correction.
Yes.
I spoke. And so again, we see that the reasoning of the tribunal is right there. It's cited to the transcript, and this is the status of the record that was before the tribunal. This is the basis for the tribunal's decision. It's articulated in the award. Slide 97. Guatemala contends that the tribunal's reasoning concerning excess but for value, now turning to the but for value, contradicted what Guatemala describes as the tribunal's two premises for its damages analysis. Guatemala spent a lot of time on this this morning. I have two short points. One is that whole discussion is contained in the tribunal's analysis of res judicata, and specifically why the original tribunal's decisions concerning damages is not res judicata as regards the loss of value damages. That's what it is. Those are not the resubmission tribunal's own premises for its own damages analysis. That discussion is provided in a completely separate section of the resubmission award. And if we look at the first premise, this is slide 97, you can see on the left the premise as Guatemala formulated it in its pleadings. And on the right-hand side, you can see the excerpt of the resubmission award is the same language, and it's plain from the text that this is a description of the original tribunal's position. It is not the resubmission tribunal's espousal of those conclusions. Let's go to slide 98. Same thing with respect to the alleged second premise. Let's go to slide 99. So Guatemala contends that the resubmission tribunal failed to consider Dr. Abdallah's corrections to Mr. Kaczmarek's but for calculation. And it says that there is nothing in the award that demonstrates that the evidence was even considered. That's false. If we look at the resubmission award footnote 122, that's the footnote we saw previously, there is a reference to the transcript of day 1 of the resubmission hearing, page 91, lines 4 to 7. And as you can see in the right bottom corner of this slide, these criticisms were expressly mentioned there, including that they would reduce the damages to $18.2 million. Again, this is the portion of the award where the tribunal provides its reasoning. So it's absolutely clear that the tribunal did consider these alleged criticisms and did not accept them. It's clear on the face of the award. Slide 100, in any event, just to give you the background on these criticisms, they were thoroughly discussed at the hearing. They were brought up during expert examinations and also during expert conferencing that the tribunal ordered. And during those discussions, let's go to, we can stay on this slide. So one of the issues that came up was, should we use cash flows to the equity holder or should we use cash flows to the firm? That's the dead horse question. The reason why it was referred to as the dead horse question is that Dr. Abdallah basically gave it up and conceded that the premises for that criticism are just not reconcilable with the way that the actual transaction happened. And that's on this slide. The other two issues that were raised, one related to the elasticity of demand, the other one related to inflation. Again, Dr. Abdallah gave it up. He agreed that those wash away. And so there's no surprise that the tribunal dealt with these criticisms the way it did in the award. Next slide. So Guatemala presents an argument that the resubmission tribunal departed or committed a serious departure from a fundamental rule of procedure as a separate basis for annulment. Guatemala raised this with respect to both the actual value and the but-for value. Again, on the actual value, this fails because the actual value adopted by the tribunal was within Guatemala's own range, so this had no impact. But in any event, Guatemala does not even clear the first hurdle, which is identifying what rule of procedure it is talking about. The pleadings Guatemala's pleadings speak about a rule. That's not a ground for annulment. One needs to identify what specific rule. One has to prove that the rule is fundamental, that it was breached, and that the breach was serious. And Guatemala does nothing of that. That's the end of its fundamental rule claim. Last slide. So this is just an example. In next era v. Spain, the tribunal did not even mention the only witness presented by Spain. And like Guatemala here, Spain complained that this was a serious departure from a fundamental rule of procedure. In that case, Spain said this was a violation of its right to be heard. The next era, the committee stated that the fact that the witness was not mentioned in the award does not mean automatically that the testimony was not considered, and that in any case, this is not a violation of the right to be heard. And in our case, we are not even close to that. And that concludes my presentation. Thank you.
Thank you. Your mic.
Sorry. So thank you. So just a few comments on interest.
1 second. Sorry. 10 minutes left.
So just a few comments on interest. If we turn to slide 104, I won't go through this whole slide, but it puts in a diagram form what was awarded by each of the tribunals and annulment committees and what was annulled. But you'll see here that if you look at the bottom, what the resubmission tribunal did is it granted interest at the U.S. prime rate plus 2% on two newly awarded amounts, on the loss of value damages for 2010 to 2013, and also on the presale interest piece. The original tribunal, as you also know, also awarded interest on the historical or loss of cash flow damages at the same rate, U.S. prime plus 2%. That's clear from the paragraph 742, where they state the loss of value damages, and then you look at the dispositif of the award, and they awarded at U.S. prime rate plus 2%. Now, Guatemala paid interest at the U.S. prime rate plus 2% on the amount awarded by the original tribunal, and we know that's the case too. The original tribunal didn't award any loss of value damages, as we know. It also didn't award that presale interest piece. That was the piece it denied on the grounds of unjust enrichment that was annulled. So it necessarily didn't award any interest on those amounts because it denied those claims for damages. If you go to slide 108, the crux of Guatemala's claim is that they're saying the resubmission tribunal was bound to apply interest at a risk-free rate. That was res judicata. There can't possibly be any res judicata effect for a rate of interest on amounts that were not awarded. The tribunal never made an award on loss of value damages, the original tribunal, so never awarded an amount of interest. So of course, the resubmission tribunal couldn't have been bound to apply that. These were new damages and new interest amounts. A second reason why there was no res judicata effect on the rate of interest from anything in the original award is, as the resubmission tribunal said, there's language in that original award which is internally inconsistent. That's paragraph 766 and 767. Paragraph 766 says, the arbitral tribunal thus agrees with the respondent that a risk-free rate should be applied. In the next paragraph, it says, the arbitral tribunal agrees with Mr. Kazmarik's evidence that the proper interest should be based on the U.S. prime rate of interest plus a 2% premium in order to reflect a rate that is broadly available to the market. So there's inconsistency there. The resubmission tribunal, now in the dispositif, it awards in 767 what it says there, which is the U.S. prime rate plus 2%, and that's what's enforced. But as far as whether any of these particular paragraphs have any res judicata effect, the resubmission tribunal says it can't, because in these paragraphs, there's no definitive ruling because these are inconsistent, and you need a definitive ruling for res judicata. Now, in slide 110, you will see, and this responds to a question that was asked today, that Guatemala not only did not argue that paragraph 766, the language on the risk-free rate, was res judicata, and that the resubmission tribunal was bound to apply interest at that rate, it argued the opposite. It argued, you're not bound to apply U.S. prime rate plus 2%, which the original tribunal did. You're free to make your own determination. And you can see that here. This is Mr. Decomp's Guatemala's counsel acknowledging the inconsistency between paragraphs 766 and 767, saying it's unclear why the tribunal decided that a risk-free rate should apply to interest and went on to apply what is effectively a commercial rate. It's a bit hard to understand the reasoning. Then in their rejoinder in the resubmission proceeding, they say what's important is that the original tribunal made no determination as to the question of interest rate to be applicable to hypothetical future damages. Therefore, this resubmission tribunal is entitled to decide the issue. You can see again on slide 111 that Guatemala is now stopped from arguing that the resubmission tribunal was bound to apply a risk-free rate, having told the resubmission tribunal, you are not bound by anything. You have to decide for yourself. It can't now seek to annul that decision by saying that they violated a fundamental rule of procedure by not applying res judicata. And if you see here on the right side of the page at the resubmission hearing, Guatemala's counsel said, the original tribunal accepted that the risk-free rate should apply with respect to the determination of historical damages. And obviously, we are not saying that this is res judicata. They expressly disavowed that that was binding on the resubmission tribunal. Then later on, he goes on to say, quote, in any event, obviously, this finding of the original tribunal is limited to historical damages and it cannot be res judicata for this tribunal. Their only other argument on interest is that there is no reasoning. This morning, you heard them say they needed a legal theory, that they said TECO was no longer exposed to the commercial risk of operating in Guatemala after its sale, and that they had no legal theory. As arbitrator Boo pointed out, if you look at slide 112, the legal theory and the legal reasoning is there. Guatemala just chooses to ignore it. They repeatedly refuse to look at anything but paragraph 131. But if you look at paragraph 133, the reasoning is set out here. And it's, quote, while it's true that claimant's investment in EGSA was no longer at risk after it sold that investment for cash, if claimant had borrowed in order to fill the gap in the sums owing to it as a consequence of respondent's breach, it would have had to have borrowed at commercial rates. And that is why they awarded a commercial rate of interest at US prime plus 2%. That amount or the scope of that reasoning is in line